Good morning, everybody. One of the most popular programs that we conduct is the one on RTI, because Mr. Shailesh Gandhi, who was the Central Information Commissioner, finished his term and came back to Bombay. And unlike most other people, he decided that he's going back to the grassroots and being an activist and an evangelist for RTI. So you actually have someone that level coming back. And he's back to being a grassroots activist. He's not just evangelizing RTI like he used to before he went to Delhi, but he's also filing RTI, filing appeals. And another thing that he does, which is of immense value to all of us, is that he's picked out RTI judgments, which when you file a second appeal can be used in your appeal if you cite that judgment. And that usually gets better results and responses. And we have just published the 200th one. Okay, so we have a whole series on the Moneylife Foundation website. So please go to the website. It's a proper section. Look at it, cite the relevant judgment so that you're going to hear more from Shailesh. A little bit of background about him. I'm sure many of you know. He's an IITian. He's an entrepreneur. And with this, I request you to take over.
Fellow citizens of India, why is right to information so important for all of us? The first Right to Information Act came in Sweden 250 years back, friends. Quite often, I heard with government officers and all saying things like democracy, right to information are all good for the affluent countries, not very convenient for poor countries like us. Think carefully and look at it like this. Governments that became transparent and democratic, institutions that became democratic, are today amongst the most affluent countries in the world. I would submit that they are affluent because they opted for democracy and opted for transparency, not the other way around. It's not that you are affluent first and then you become democratic. It is that if you become a democracy, and I would submit that in India our problem is we do not have what I'd call a deep, meaningful democracy. And why am I saying that? You will say we are all voting every 5 years. Next month we go and vote, and this month we go and vote, and we'll get the government that we vote for. I would submit to you that elections and a constitution are necessary conditions for a democracy, but are not the complete set of conditions. There is something very basic for democracy which we've missed. The fundamental concept of democracy is that each individual citizen is a sovereign in her own right, and she gives up part of the sovereignty to the state in return for which she gets the rule of law. It's a negotiation of each individual citizen. We talk of the word Lokshahi. Lokshahi means logon ki shahenshahi. You, sir, should feel like a Badshah, and you, ma'am, should feel like a Begum when you go to a government office. Some people tell me, Shailesh, you're playing with words. Can we have 125 crore Badshahs and Begums managing India? And I would submit yes. It happens in all countries. And let me give you a very simple example, and then I'll take you on to right to information. In the United States, I'm not an admirer of everything in the West, but I think in terms of democracy, they have performed better than us. In the United States, for example, an immigrant from any country, if he or she has applied for a green card or citizenship of the United States, will easily pick up the telephone to ask about the status of their application. And 99% will get a very rational answer about the status of the application, when it's likely to be considered, etc. All of you are first-rate citizens of India. If you have applied for a passport and your passport gets delayed, will any of you think of picking up the phone to ask? No. Why? No, supposing you find out the phone number, yeah, you are 100% confident that if I call up after finding the phone number, etc., therefore you feel there's no point of even finding the phone number, why go through that exercise? But that's the point I'm making. Respecting and recognizing individual rights, respecting individual human beings, whether citizen or not, is something that we've missed very badly. And until we restore that, I would submit, no matter how all 100% of us can go and vote, we will not reach a deeper, meaningful democracy. I'm not saying we shouldn't vote. We should vote, certainly. There are various institutions that are necessary, but the most important of this is respect for individuals. And that respect for individuals, at least citizens, is what right to information does. And that's why I feel very passionately about the right to information. I think this is for the first time a tool that empowers an individual citizen sitting in their own house and feeling empowered that I can make the government work, I can make the government answer, I can make the government give information. So this is kind of at the basics of this. Where did right to information start? Worldwide, I'll come to that. In India, it's very interesting. This is a story I'd like to share with you. 1992, go back to 1992, and in Rajasthan, in a small village, there were some people who had understood the concept of democracy and said, we are the Badshahs and Begums of democracy. In a town meeting, in a village meeting rather, they were sitting and discussing about corruption. The usual crib sessions that all of us specialize in. Okay, we crib about what's wrong and everything is corrupt and nothing is good and so on. And there was this old lady of 80 years who said, why don't we go to the block development officer's office and ask to see the accounts of the last 2 years of money spent in our village? Someone said, who'll show it to you? I mean, what right do we have? They'll throw us out. And she said, ये लोकशाही है, मैं इस देश की रानी हूँ, और अगर मैं इस देश की रानी हूँ, जो पैसा सरकार खर्च करती है वो मेरा है, और अगर वो पैसा मेरा है तो हिसाब लेना मेरा अधिकार है. मेरा पैसा है, मैं हिसाब लूंगी. They actually went to the BDO's office, got thrown out completely. And the BDO said, who the hell do you think you are? They sat on a dharna there. Ultimately, the collector came, the minister came, and these accounts were shown to these people. We didn't have a formal Right to Information Act, but the concept was recognized that citizens have a right to understand and to get information about whatever you do with public funds. In that case, they discovered some small corruption, and then, of course, there is a long story to that. But this is why it's extremely important. Remember, an unsophisticated, illiterate 80-year-old lady came up with this concept. I quite often hear that the education will solve everything. Education will solve nothing unless you start taking it into your own hands. Whether you're educated or uneducated, when you understand meaningfully what democracy is, when you exercise your rights, that's when we get a democracy. Very well, friends. Now, what I'm going to do today is, I'm going to take you through some of the provisions of the RTI Act. Towards the end, I will try and explain to you how actually an RTI application is filed and a first appeal is filed. And after that, I'm going to take the liberty of spending 10 minutes on a topic not really related to right to information, but a topic about which I'm very passionate nowadays. There's a law in Maharashtra called Transfers and Delays Act. So it's an unrelated topic, but I'm going to take the liberty of spending 10 minutes of yours to explain what it can do, because I have a feeling, I'm not sure, that maybe it may actually prove to be as important as right to information, if not more. So I see that potential. I don't know what will happen, but I'd share that with you. Worldwide, the right to information is known by 3 different terminologies. Freedom of information, FOI, right to information, RTI, and access to information, ATI. Different countries have different names, so these are equivalent names. The first Freedom of Information Act was enacted in Sweden on 2nd December 1766. And it's very interesting to understand, it was primarily sponsored by a Finnish clergyman, Anders Shedinus. And what inspired him? Confucian philosophy, which goes back to 5 BC. And what was the key to this? That Chinese emperors were expected to admit their imperfections, even as they were to have infallible and exemplar personal conduct. Confucian philosophy 2,500 years back expected that the emperors of China must behave well and admit mistakes, to my mind, right to information is largely about admitting mistakes. If you made a mistake, admit it openly. You may not even realize, and mistake admission is a big thing. All of us, I don't realize every time I make a mistake, but somebody usually points out. Students in an examination, they don't know what mistakes they are making or what knowledge they lack, but somebody points it out to them. The moment somebody points it out to them, they have a chance of correcting themselves. So this really is the essence of the right to information, a vibrant democracy where citizens will look at various information, point out what may be wrong or what they believe is wrong, and therefore correct whatever is actually wrong. The preamble of any act is the soul of an act. It says what the whole objective of the law is. I'd like to read this preamble of the act with you. Whereas the Constitution of India has established democratic republic, and whereas democracy requires an informed citizenry and transparency of information, which are vital to the functioning and also to contain corruption and to hold governments in their instrumentalities accountable to the governed. And whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal, now therefore it is expedient. All the problems associated with introducing the right to information in a codified form were recognized by Parliament, and they have harmonized this in this law. I'm telling you this because a lot of extremely important people in this nation, from Supreme Court judges to the the present Prime Minister of India, and whoever may be the future Prime Minister, most of them are no longer very fanciful. They like to talk about right to information as a big thing, but really they don't have their heart in it. They say we have so many problems, we have this, that, that. All this was thought of. The preamble clearly indicates that these were thought of. And when did we get the right to information? Incidentally, I want to bring to your attention the fact that the Supreme Court has held time and again, before the RTI Act came, that right to information is implicit in the freedom of expression that we talk of under Article 19. Because without the right to information, expression is meaningless. If you do not know, you cannot do anything about your expression. Your expression is not meaningful. Therefore, the right to information existed the day the Constitution of India was made on 26 January 1950. Then what is this law? This law, which came in 2005, has only codified it to give you a structure as to how to apply, how to get information, what information can be denied, what information cannot be denied. That is all this law does. Okay. What is information? Information means any material in any form, including records, etc., etc., held by any public authority. In very simple terms, let me describe this, because I've seen people using right to information for years. I've seen commissioners who also become right to information commissioners only because of the salaries and perquisites that they get, not understanding what is information. What is information? Information is what exists. If it exists, it's information. If it doesn't exist, it's not information. To give you just two simple examples, supposing you were to go and say, when will all the roads of Mumbai get pothole free? If there is something on the files that says or lays it down, then it's information. But if there is nothing, it's not your right to question an officer and say, no, you tell me. I've got right to information, I want an answer for this. Why was such an action taken? If there is something on the files, that's information. But if there is nothing on the file, that's not information. Keep this in mind. We'll come back to it in a little while. Now, we understood what is information, what exists in information. Who has to give information? The Act defines what is called public authorities. What's a public authority? The first four A, B, C, D, by and large, would include everything that you call government. Really speaking, for example, Bombay Municipal Corporation is not state government. It's a different body. Panchayats are not state government. Therefore, everything that applies to them does not apply. But in normal terminology, everything that we call government, whether it's Panchayats, Bombay Municipal Corporation, anything that you call government is included. Anything notified by government is included. Also, the law says and includes any body owned, controlled or substantially financed. Non-government organizations substantially financed directly or indirectly by funds provided by the applicable government. So if therefore your aided schools and private colleges are included because they are substantially financed by government. If an institution is controlled by owned, of course, obviously, but even if it's substantially financed, then these organizations all are public authorities which are mandated to give information to any citizen of India. What is right to information? Means the right to information accessible under the Act, which is held by or under the control of any public authority, and includes the right to inspection of work, documents and records. Most of us are not aware of the fact that we can actually inspect a work also. You can say, I want to do an inspection of the road construction going on here. I would like to do an inspection of even, you see, this is not being used very much, but you could actually say, there's a structure here, I want to inspect the structure with you. These are things which are on the borderline of the right to information, not used, but if we start using it, maybe we'll reach there. Most PIOs will say, we won't give you an inspection of this nature. Aisa hota hi nahi hai. They have, because nobody reads the law. But really speaking, you can do this. Second is what most of us do, taking notes, extracts or certified copies of documents or records. This is what most of the RTI is about. Taking certified samples of material. You can also, if you believe that some material is defective, you can ask for a sample of the material, get tests done and show that it's defective and so on. The most important section of the Right to Information Act is the shortest one. I'm not saying this because I'm short, but short people have a lot of merit in them. This is the shortest section. Subject to the provisions of this Act, all citizens shall have the right to information. Your right to information is only curbed by the provisions of this law. Nothing else can curb your right to information. Therefore, what information may be refused is also what is given in this law. Outside of that, there is nothing that somebody can refuse to you. And if you are a citizen of India, you are entitled to get information. Section 4 is an extremely important section which lots of people talk about it, but nothing is done about it. Section 4 is really the heart and essence of this law, and if it was fulfilled, and unfortunately most citizens are also not demanding it. There's not, if we put up a big fight on Section 4, we need not even file RTI applications, my friend. There are 17 points which say various things must be displayed and put on websites as well as in offices. You should be told norms for work, how will the office work, who is responsible, wide variety of information is supposed to be displayed. The computerization is one of the key things. And let me share a simple dream with you. If, believe me, most government offices have computers, most of which are used as electric typewriters. Okay? All the work is done on paper files. And because of this, what happens? This is something you must have all heard. You go to an office for some work and you are told file nahi milta hai. You pay money, file mil jayega. You pay money, the file can be made to disappear. You pay money, a record can be substituted, a record can be altered, changed, all of this. 30% of India's corruption takes place by this simple device of having these paper files. If on the other hand we banished paper files, did all the work on computers, transmitted files, entire files only on computers, no paper, I'm saying do not create paper. Computer systems have built-in systems by which if you alter anything, delete anything, you can figure out from where it was deleted and where it was altered. And what it was before that. Even a fire like the one in Mantralaya, they said records khatam ho gaye. Will not destroy this because usually you could have, for things in Mumbai, you could have a backup in Hyderabad. That even if an earthquake were to hit Mumbai, your records would still be available. Extremely simple thing. It would also save, to my mind, at least over 1,000 crores or more of paper and files. And equally important, space to keep these files. Please look at it like this. And because of the nature of the way government works, most files they can't find. So we say we spend a lot of money on creating paper files, keeping them, which is very difficult to access. On the other hand, if you have a computerized system, almost everything would be available at the touch of a button. B, every day the government works. By the end of the day, except something that may be exempt, all the information could be on the website. Citizens could look at the information from their houses. For those who can't use computers, people may go to a cyber cafe and get it. Most of the RTI applications would not be necessary. But this is something to which very little attention is being paid. Proper implementation could improve working efficiency. It would also make the PIO's job. The PIO is incidentally the Public Information Officer. Section 6. A person who desires to obtain any information under the Act shall make a request in writing or through electronic means in the official language or English or Hindi. An applicant making requests for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. Now, when I talk to government officers in workshops like this and I ask them that not giving any reasons, do you think it's fair? What do you think? Don't you think people should give reasons for asking for information? Why? Why? Why do you think like that? Sorry? True. Information belongs to you. Everything in government, every table, tube light, chair belongs to each one of us. We can't take it away because it's a joint ownership. But it belongs to us. Similarly, all the information on the computers, files of the government belong to each one of us. We are not taking it away. We are only getting a copy or extract out of it. And because it belongs to us, remember, begin to understand that you own the information. When you start believing you own the information, your whole approach will change. Quite often people used to complain to me as a commissioner and even subsequently, Mr. Gandhi, we went to that office 5 times, 10 times. वो बहुत परेशान करता है हमको. The commissioner people will come and tell me, sir, ये बहुत परेशान करता है. मैं 10 बार गया. So I used to tell them, why do you go 10 times? No, he used to make promises to me. So I asked them, are you a bhikhari? People would feel very insulted. Mr. Gandhi, no. What do you mean we are a bhikhari? I'd say, you're acting like a beggar. You go there 10 times. The beggar, when I'm at a signal, she comes and says, sir, dijiye. If I feel like I may give her, I may not give her anything. Don't go to government office as a standard rule, let me tell you. By and large, do everything in writing. Leave nothing verbal. Apply in writing and ideally send right to information applications only through speed post is my suggestion. Don't even, you can theoretically, there's no legal bar to going and giving it there. Quite often when you go and give it there, somebody will say, ye idhar nahi hai, udhar nahi hai, I will not take it, right person is not there, come tomorrow, etc. Don't allow anyone to humiliate you like this. Send it by speed post, take a speed post tracking report after 3-4 days from the website and keep it with you. That's all you need to do. You are a sovereign of this nation. As this lady said, Badshah and Begum. The Badshahs and Begums don't go about like beggars to various offices. Okay? Disposal of request. On receipt of a request, the PIO shall, as expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in sections 8 or 9. Can an information request be rejected? Yes. Only based on the provisions of section 8 and 9. Section 9 I am not dealing with because section 9 deals with only copyrights. So, I mean, let me tell you in simple terms, supposing there is a book, copyrighted book in the government office, you can't say give me a photocopy of that. So that's what copyright is. Section 8 we'll deal with. Only subject to that. Nobody can tell you it's confidential. Nobody can tell you I don't want to give you information. There is no such option to any government officer. If PIO fails to give decision on the request for information within the period specified, which is 30 days, the PIO shall be deemed to have refused the request. In 30 days, if he does not respond, it means he has refused it without any reasons. And this will have some of the implications which we'll come to. PIO must give details of further fees. Now, okay, there is some fee, usually 10 rupees in most places, which has to be paid with the application. In Maharashtra government, the most convenient way of paying this fee is to take a court fee stamp of 10 rupees and stick it on your application. You can go and pay cash, etc. I'm not saying you can't do that, but this I'm saying is the most convenient method. For central government bodies, court fee stamps will not work. What will work is getting an Indian postal order of 10 rupees available at most post offices. Attach it to your application. Don't stick the Indian postal order on the application, because they can cash it at a post office for 10 rupees. So central government bodies, Indian postal order of 10 rupees. Maharashtra government, 10 rupees court fee stamp. Different states will have different rules, so you'll have to look at that. That is the application fee that you pay. Where do you get a form? You go nowhere to get a form. Any plain piece of paper is your form. Maharashtra government has a format, we'll come to that. Central government has no formats, but I would advise you can use the Maharashtra format to apply to the central government, because it's a really neat format. It's only a format, it's not a form. So take a plain piece of paper, make your application, stick a 10 rupee court fee stamp, or central government, attach a IPO for 10 rupees. After that, supposing you want information consisting of 100 pages, the Act prescribes that a fee can be charged to you. The fee in Maharashtra is 2 rupees per page, central government is 2 rupees per page. I'm not going into various state complexities, 2 rupees per page. But what does the law say? The law says the PIO must tell you that you have to pay so much fee because the information you are asking is so many pages. Of course, if it's larger drawings, etc., then at actual cost. And he must tell you why he is charging you so much money. He has to give you a calculation saying the information is, let's say, 70 pages into 2 rupees plus something, say for drawings if you ask for, and plus postage cost. Maharashtra, the postage cost has to be paid by you. In the central government, the postage cost is included. These are the differences in the rules. Now, what this says is the period intervening between the dispatch of the said intimation and payment of fees shall be excluded. I will just explain it in a slightly different form a little later. Person making request for the information shall be provided the information free of charge where a public authority fails to comply within the time limits of 30 days. If after 40 days or 45 days information is given to you, no charge can be levied on you. The government is supposed to bear that charge. Where a request has been rejected under subsection 1, the public information officer shall communicate to the person making the request the reasons for such rejection. If an application is rejected or request is rejected, the reasons have to be given. The period within which an appeal against such rejection may be preferred, within 30 days of getting an order from a PIO. If you are dissatisfied, you must file your first appeal. This is important. I've seen most people filing an RTI, not pursuing with an appeal if they've got no reply. If I get no reply, what do I do? If I get no reply, within 60 days is your period, because within 30 days it's a deemed refusal. Let's say PIO received the RTI application on 1st January. If you receive no reply by say 5th of February, you should file your first appeal. And the latest is 30 days from 30th January. Within that, if you don't file, your first appeal may be time barred. Public information officer I mentioned. Where do I find and how do I know who the public information officer is? The Act has made it extremely simple. A, every public authority at every office, I repeat, every public authority at every office has to have a public information officer. You just think of which government office and which office is likely to be having that information, and write public information officer at that office address. There has to be a PIO. They have to accept it. You don't need the name of the public information officer. It's like saying, if I want to write to the principal of St. Xavier's College, I don't need to know the name of the principal. I can say principal, St. Xavier's College. There has to be a principal. If the principal is not there, there has to be an acting principal. Somebody has to accept that. So you do not have to worry about finding out the name of the PIO or his exact thing. All you need to know is the office. If you send it to the wrong PIO by chance, I mean, here let me sound a note of caution. Let's act as responsible citizens. Try and find out within reasonable limits as to where the information is likely to be. But quite a lot of things you will not be able to figure out. Send it to the best thing that you can think of. The law says the PIO cannot return your RT application. If he is not the right PIO, it is his duty now within 5 days to transfer it to the right PIO. But as I said, note of caution is, let's use this act responsibly. I've seen some people who send all RT applications for central government to the Prime Minister's office, saying law says he has to transfer. That is irresponsible. I mean, that's clearly irresponsible. It's our government. We want our government to function well, not just do unnecessary things. But in case it is going to the wrong PIO, he cannot return it to you and say that I don't have the information. He has to transfer it to the person who has the information. Okay. Now, 9 is extremely important, 7-9, because this, again, lots of PIOs, government officers and citizens are confused about this. What does it say? An information shall ordinarily be provided in the form in which it is sought, unless it would disproportionately divert the resources of the public authority or be detrimental to the safety. We leave that safety part out. Unless you are looking for 100-year-old documents, then that will apply. But most of the things that you are likely to be interested in. Supposing you say, I want details of the last 5 years of your accounts in this format. Or you say, let me take a very simple case. Suppose you say, I want to know the number of chairs purchased by an organization and the total amount spent on it. Taking a very simple, sounds almost stupid. And people have asked such questions incidentally. Now, unless there is a category where the public authority is mentioning chairs separately and keeping an account of number of chairs, which is unlikely usually, they cannot give you the information. It's not readily available. You might say it's available on the bills, but to provide that information to you in that form, somebody will have to sit, go through the 5 years accounts, locate each chair, collate that and give you the information. This is not expected. And you may say, oh, this is absurd, but people have asked all kinds of absurd things at times. There was a lady who had come and appealed to me once, and one of the questions she'd asked Delhi government education department was, she said, for all teachers in Delhi government whose name was Seema, since beginning, I want the following information. Now, it'd be impossible to do something like that. But the law says it cannot be refused. Information cannot be refused if it's not available in the form in which it is sought. Let's look at it like this. There would have been on the records of Delhi government teachers named Seema. So the records were available. Question is how to get it out. The PIO has to offer you another alternate means, which means either an inspection or say, I'll give you a photocopy of the Seema thing. Was of course a ridiculous thing that even if somebody wanted to would be impossible to do. But if you say, I want instances where in the last 3 years you spent on repairs and maintenance, and what is the bill? Now it may not be collated, but you can go and inspect the files, or a PIO can tell you this will comprise over 20 files or 50 files, it will be 5,000 pages at 2 rupees per page. If you pay 10,000 rupees, I'll give you the information. 7/9 is quite often used by PIOs. They don't even know 7/9. They just say in this form it's not available, which is wrong. You must fight this. And when you ask for simple information, it has to be provided. It is not some PIOs. I was with a senior secretary in Mantralaya yesterday, and he said, Mr. Gandhi, RTI is just giving photocopies of records. Flawed. If what you are seeking would need a lot of time, then the PIO is not expected to collate it. But if it can be done in 10 minutes, 15 minutes, half an hour, 1 hour, PIO is expected to collate that information and give it to you. But let's be reasonable in our expectations also. You have to think of how, if it's not available in a collated form, ask for it in whatever form they have it. Now the 30-day period, I had promised to illustrate this. The day that you file the RTI application is not day one. The day the PIO receives the RTI application is day one. Supposing PIO sends letter asking for additional fees, 30-day clock stops. Let's assume for a moment, 1st of March, the RTI application reached the PIO, the Public Information Officer. 12th of March, he dispatches a letter. His letter is dated 12th March. You may get the letter on the 15th March or 18th March. But the moment 12th March he signs that letter, the 30-day clock has stopped. You receive the letter, say on 18th March. You may not go immediately and pay the money. You may pay it on 25th of March. For this period, until you pay the money, 25th March, the 30-day clock starts again. So if 12 days have gone initially, the PIO has got 18 days more to give you the information. Okay, so this is the way the 30-day clock operates. Also, the PIO cannot tell you, I sent you a letter for fees on the 30th day. He may do that. The moment you pay, he must be able to give you the information. What the law actually expects is that PIO is not expected to keep the information ready for you. After you pay the fees, he or she is supposed to generate the information, give it to you. A small caution again, sometimes if you've sought information of 2,000 pages or 1,000 pages, then you got to look at this period with a slight liberal mind, because don't insist and say, I can ask because the law says 2,000 pages, no commissioner will hear you. Okay. Now this is an extremely important part of what information shall not be given. Exemption from disclosure of information, section 8(1). And we take a look at it together. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen information, disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relation with foreign state, or lead to incitement of an offense. Seems reasonable, but sometimes misused also, this exemption. I'll give you a case to help you explain, to help you understand what I'm talking about. A government had set up a committee under Dr. Madhav Gadgil, who's one of India's very renowned environmentalists, and a group of people to study the ecology and environmental effects, etc., of Western Ghats going right up to Kerala. This committee spent 2 years preparing the report, and then they gave the report, which identified various places like ecologically sensitive, which, as far as I can figure out, means that other developmental activity must not be carried out there. The government thought this would hurt a lot of vested interests, so they kept the report in their drawers. Somebody asked for a copy of the report under right to information. PIO refused it, claiming 8(1)(a). Matter came to me as a commissioner, and I asked the public information officer, I said, first, 8(1)(a), you just can't say 8(1)(a). You have to give some reasons. It may be brief reasons as to how 8(1)(a) applies here. No, sir, 8(1)(a). I said, okay. Now I'm going to read out for you. Information disclosure of which would prejudicially affect the sovereignty and integrity of India. If you give a copy of this report, will it affect the sovereignty and integrity of India? So he said, no, sir. And I'm telling you some of these so that you will also figure out how you can argue before people. They said, no, sir. I said, fine. The security, strategic interests of India, he couldn't figure out how he could lay his claim to that. Then I said, scientific interests of India, he couldn't figure out how scientific of India. I said economic interest. Now that is the last one. If he says no to this, there is nothing beyond that. When I said economic interest, he said yes sir, economic interests of India. I said very well, tell me how the economic interests of India will be hurt. No sir, economic interests, I mean. Ultimately I gave a decision which has led to release of this report, and it's creating a lot of debate in the country. So my point is, don't just take anything lying down. Reason it out. It may really apply. If it really applies, accept. Don't unnecessarily pursue it and say, nahi, mujhe hona chahiye. Take a reasonable, rational view of this. The objective is not to harass people. It should never be our objective. The objective is not to be confrontationist. But what is your right, you must get. B. Information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Now, given this section 8(1)(b), do you think sub judice matters information can be provided? Yes or no?
Yes.
Everybody says yes, or there are some who believe no? No. Okay. Yes, why do you say sir? No. Any lawyers here? Are there any lawyers in the... No. Okay, it doesn't matter. Tell me, why do you think it's no?
I don't know. It's disputed. Why ask for
No. What is disputed? There is a dispute. What has that got to do with information? Sorry? It does not amount to contempt of court. We've been living with this fiction of sub judice. And all of us, we just use a word, you say sub judice and everybody says khalas. This law certainly does not exempt sub judice matters. It only says which will constitute contempt of court. For example, if a court has said this information is not to be disclosed, then you can't disclose it. Alternately, supposing a hearing is being held in camera and there are any information regarding that, it can't be given. In camera obviously means you cannot disclose that information. Short of that, sub judice is no bar. Sub judice is an unnecessary fiction we've created in India. Everything sub judice, people just say sub judice. That's all. For anything and everything we use this word, just because things are in court, and mind you, let's understand, our courts take decades to resolve anything. So by sub judice, if we were to allow as a matter of exemption, I think we would not get much information. Anyway, see, information, the disclosure of which would cause a breach of privilege of Parliament or the state legislature. What is this kind of information? For example, if the budget is going to be presented, and before that you say, I want the budget papers, it can't be given to you. A lot of inquiry commission reports, incidentally, this is something I'd like to share with you. Before the RTI Act came, the standard practice, they'd have an inquiry commission, keep it in there if it's inconvenient. The Adarsh Commission report is an example, recent example. They just said not disclosing. And if you ask for the report, they would say breach of privilege of Parliament or legislature because we've not presented it to Parliament or state legislature. I was involved in a bench decision that we gave in the commission. There was such an inquiry commission report which had not been released for about 2 years. And the matter came before us and government said, we've not presented it to Parliament. We looked at the Commissions of Inquiry Act, which says that under the Commissions of Inquiry Act, any report that is prepared has to be presented in Parliament or legislature within 6 months. Therefore, we ruled that in 6 months, first 6 months you can claim breach of privilege. Once the 6-month period is over, you cannot, it means you don't want to present it. I mean, we are not concerned with anything. You will have to give it to citizens. Therefore, now, after the period of 6 months, reports are being given to citizens because there is no legal bar based on which they can claim that we will not give it because of breach of privilege. D. Information including commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive position of a third party. The operative part is harm the competitive position of a third party. Therefore, you will have to show that A, the information which is being denied is of a commercial nature, or a trade secret, and giving it will harm somebody's competitive interest. I'll give you a simple example for this. We had a case before us where there was some information about a transaction held 8 years before, and this was claimed as an exemption. They said this is commercial information, and I asked them, I said, after 8 years, supposing you have a price information or whatever it is, how can you hurt somebody's competitive interest? Think carefully. Yes, if it's 6 months back, it will hurt somebody's competitive interest. If information has been provided by somebody which is of a commercially sensitive nature, you can take that claim. But 6 years, 8 years later, there can be no competitive interest that can be damaged. Therefore, if it is going to, if you can show that somebody's competitive interest will be harmed, only then can this exemption be claimed, not otherwise. E, information available to a person in his fiduciary. Now there is a larger public interest which is also coming later on, so I'll cover that later. Information available to a person in his fiduciary relationship. What's a fiduciary relationship? How many of you think you know? One? Okay. Yes, sir, please. Now, this is a very honest audience. In government, let me tell you, very few people know the meaning of fiduciary. They never knew. But because the act has come, this is quite often used as a thing. मतलब ही नहीं मालूम है तो क्या? Fiduciary है. Yeah, please, sir.
Doctor-patient equivalence is something like malaria and all that, where the disclosures have to be made.
No, the key elements, okay, you are right, sir. Doctor-patient is one fiduciary relationship. Lawyer-client, banker-client, consultant-customer.
Also privileged.
Yes, but there are certain characteristics of this. You know, when you say privilege, then again we go and say, what is privilege? A fiduciary relationship, also, let's say in a Catholic or the Christians, when they go before a father and make a confessional, that would be that is
faith and trust.
no. So let me try and define this for you, man. The key element is that the person who gives the information to somebody superior, we call it a superior person, does it for his own benefit. You give information to your doctor, your lawyer, your banker, your consultant for your benefit, because you expect to get some benefit by giving that information. B, you have a choice of whom to give the information, whether to give the information or not. There is no law. You may go to a doctor, you can lie about some of your issues. There is no law that you are violating. You can go to a lawyer, you may have actually committed a crime, and you can lie to him, and there is no law that you are flouting. Also, you go to such people because you trust them. See, trust is a very key element of this, but just because you trust anybody, it doesn't become a fiduciary relationship. Quite often, how it is used is, because somebody trusts me, it's a fiduciary relationship. Everything where I trust you or don't trust you is not a fiduciary relationship. There is an element of choice. Only then the issue of trust comes. Most of the things which are refused under fiduciary today in India actually are statutory. There's a difference between statutory and fiduciary. If I provide information because of a statutory requirement, whether I trust or don't trust is irrelevant. My income tax officer, people have claimed fiduciary relationship. I may dislike the chap, I may mistrust him, I may think he's a rogue, but I have to give the information. The inspector who comes and takes information, or I give information to BMC because I have a trade license or whatever, I may feel the chap is a rogue. But because there is a law, I have to provide information. When I go and apply for a passport application, I have to give information because there is a law. So this is clearly different from, so therefore, however, supposing I go to a government hospital and I get treated there, that is information that the hospital and the doctors hold in a fiduciary relationship with me. If I go to Bank of India and have an account in Bank of India, information about my account held by Bank of India is held in a fiduciary capacity. So this is clearly different, and therefore the wide expansion of fiduciary, quite often you will find, please, if it's refused, ask for it, argue about it. information received in confidence from foreign government. Note, the only place where the word confidence or confidentiality is used in this law is information received from a foreign government. Other things, nobody can say this is confidential information. Confidential word is banned, except for information provided by a foreign government. So if information is provided by a foreign government, they can claim and say, sorry, this is provided in confidence, I can't disclose it. That's the reason why the government takes a position that on black money transactions, etc., whatever information foreign governments have given to them, they will not share. This is the exclusion clause that they use. G, information the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence. So this would be like somebody's complained about something. If you believe that disclosing this information will endanger somebody's life or physical safety, then you can deny. But this also can be used very trivially, and I'll just give you one instance of this, and this happened before me. The Employees Provident Fund organization, some employee had asked about the remarks given by his superior regarding the applicant. And this was refused to him using section 81G. The matter came before me and I said, please tell me, what is your basis for refusing? He said, sir, this. I said, are you saying, I first told him, I said, I would suggest you are using it wrongly. No, no, sir, we believe this. I said, okay. So you are telling me that you expect your employee will hurt, assault his boss if this information is given to him. Yes, sir, we believe like that. Fair enough. I used to dictate my orders immediately, and in 5 minutes people would go out with an order. So I started dictating the order right in front of those people. I said, so the public information officer says that some of their employees are gundas and badmashes. We said, sir, please don't say that. I said, if you have employees who will go and hit and assault and you normally think it's a reasonable suspicion, then I'm sure you have got gundas and badmashes. He said, sir, please don't write like that, we'll give the information. So I'm saying, look at things carefully, and there may be actual situations. If there is an actual situation, accept it. Okay. Information which would impede the process of investigation or apprehension or prosecution of offenders. Do you think while an investigation is going on, information can be given? Yes or no? Yes, sir.
May not be given.
No.
It can be given. If it's mutually
The law says, I mean, I'm trying to define what the law says. The law says will impede the process of investigation. So therefore, a public information officer will have to show that if I give this information, it is likely to impede the investigation, or if a prosecution is going on, the process of prosecution. I dealt with many cases of this nature, and barring 1 or 2 cases, in all the others I had actually disallowed this. Because if wherever there is an investigation going on, people would say, just because an investigation is going on, you cannot refuse to give information. The public information officer has to show how giving the information will impede the process of investigation. Then, cabinet papers including records of deliberations of councils of ministers, secretaries and other officers. It's a very interesting thing, but I'll leave that out because otherwise we'll run short of time. Okay. And I'm guessing most of you will not have something of that nature. Section 81J, extremely important. This is another very, like the fiduciary one, 81J is another very, very popular exemption. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. First, it must be personal information to qualify for this exemption. Companies, institutions cannot have personal information. Therefore, information relating to a company or institution or firm cannot claim exemption under 81J. If it is personal information, then the disclosure of which should have no relationship to any public activity or interest. Which means that if, for example, you, again, going back to simple things, if you file an income tax return, that's a public activity. All these things are public activities. What is not? For example, an NGO may have information about individuals. which may not be a public activity at all. That would get covered under this. Even medical records could because that would be unwarranted invasion on the privacy of an individual. But this is used so often and so widely that it's not funny, really. And therefore, Parliament had given a specific proviso only for this clause. It said, provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. So my submission to you is, if at all this is used by somebody, say, even if the other arguments people are not listening, say, sir, please write, you will deny this information to Parliament or state legislature. Because the law says that. The law says this reply affects only to 81J, not to the entire clause. But for 81J, that information that is denied to you the PIO must feel that I will deny it to Parliament or state legislature. Otherwise, he cannot deny it to you. Now there is a section 8.2, which says, notwithstanding anything in the Official Secrets Act, nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. If there is a large public interest, and I'll come to the example my friend was quoting, this happened about 6-7 years back, before I had become a commissioner. There was a forest minister of Maharashtra, Mr. Swarup Singh Naik, and the Supreme Court had given rulings that no sawmills could be permitted within the forest area or maybe adjoining that. But Swarup Singh Naik was merrily flouting that. One can understand why. I guess he must be making a lot of money, so they were giving permissions. The Forest Secretary Forest was also apparently involved in this. This matter went to Supreme Court. Supreme Court sentenced Swarup Singh Naik and the Secretary to 30 days imprisonment. Now there is so Swarup Singh Naik was taken to Thana prison. There is a tradition that all powerful criminals follow whenever they have to go to prison. They complain of pain. Where? Chest. Which side? Left side. Okay. So the pain is only on the left side of the chest. So Swarup Singh Naik also said, I have to keep tradition. He also complained about pain in the left-hand side of the chest. He was promptly taken to JJ Hospital from Thana prison, kept in a lovely ICU, air-conditioned, comfort, and they said he'll spend his prison days here. This came in the media and so on. After 6-7 days, I filed an RTI application saying, I want the medical records of Swarup Singh Naik. Now, I said, I concede that these are exempt under the law. But there is a very large public interest in disclosure of this. Two things I argued. A, I said he's not a private person. The laws of privacy normally apply to a private person. He's a convict who is treated differently. You and I have certain rights. The convict doesn't have all those rights. B, I had argued that most people suspect that he is there fraudulently. And therefore, A, he's denying a needy person the facilities of a hospital. B, he is not going to prison and therefore frustrating the whole objective of a punishment. And there is a larger public interest in knowing this. If medical records show that he genuinely needs that, people will have more faith in the system. And if the medical records show that he does not deserve to be there, there is a large public interest to this. PIO refused it, claiming medical ethics, this, that, everything. First Appellate Authority, Dean of JJ also refused it, went to the commission. Unfortunately, most of these commissioners are also political appointees and they feel obliged and so on. So, whereas he couldn't deny my argument, I told him, I said, sir, do one thing. If you want to reject my application, put down in writing saying that this is not in public interest. I said, public will laugh at you. If you feel like rejecting, you will have to mention that I'm arguing, saying there's a larger public interest. If you want to reject my application, say it's not in larger public interest, but fear the public laughter at you. That also he was unwilling to do. So they delayed that by about 6-8 months. Ultimately, after a year, they gave an order saying this information will have to be provided. Because they had taken 1 year over it, they were able to substitute 1 or 2 papers. Therefore, we couldn't show anything. I mean, it was evident that there was no real medical reason. But what they showed was that medical things were okay. What they showed is that they showed a letter given by one of the doctors on the 10th or 12th day of his stay in the hospital, saying certain tests need to be conducted on him, mind you. And we need permission to take him to another hospital because we don't have the facility. And it was shown that the prison authorities didn't give permission and delayed it. I am saying even any normal convict, if he has a heart condition and the hospital asks for permission, no prison authority will dare to refuse it. And this was a minister. But it was shown that for about 15-20 days, he was kept there because of lack of permission by the prison authorities for some tests. So because of that, we couldn't do much with it. But an interesting outcome of this was, within 20 days after this happened, he went to court, lost in the court. Within 20 days of that, another powerful minister was to be sent to prison. He also complained of pain in the left-hand side of the chest. No hospital was willing to keep him. All hospitals said, no, RTI mein anybody can now come and ask and we will not be able to refuse. So we improved, I mean, RTI also improves the health of people in prison. Okay. Now, there's a provision called Section 18. Incidentally, Public Information Officer, a Public Information Officer in an office is any officer who's doing some other work and is additionally designated as Public Information Officer. Okay. Section 18 is for complaints. When do you file a complaint? When the complaint is filed to the Commission. Okay, now let me also explain the structure to you. There is a Public Information Officer who's your first interface. If you are not satisfied with the outcome with the Public Information Officer, you must file what's called a first appeal with the First Appellate Authority. Who's the First Appellate Authority? The First Appellate Authority is an officer in the same department, senior in rank to the Public Information Officer, who is supposed to perform a quasi-judicial function and decide whether you are right or the Public Information Officer is right. Time to file your first appeal within 30 days of getting an order from the PIO. Supposing he gives no order, within 30 days of the deemed refusal, which is 30 days. Okay, so outside 60 days you must file. But supposing he gives you a rejection on the 10th day, within 30 days of the 10th day, you must file your first appeal. Supposing the law requires him to actually tell you who the First Appellate Authority is. Supposing he doesn't reply to you, or he replies and doesn't give you, then how do I file a first appeal? A simple technique, this is not part of the law, but a simple way of doing this is write to the First Appellate Authority, care of Public Information Officer. And below that write that the law requires the Public Information Officer to give me the details of the First Appellate Authority. Since he has not done it, either because he has not replied or has not given it in his reply, I am now sending it to the PIO whose responsibility it is to give it to the First Appellate Authority. Okay. The First Appellate Authority has to give you a decision within 30 days, or he can extend it by 15 days. So effectively 45 days you can take it. Couple of things can happen. A, he gives you a decision that you like, you get your information, end of story. You get a decision, you are not happy. When I say happy, please understand this happiness and unhappiness is not your state of mind. It's a question of whether, as per law, he has dealt with your application. If he's dealt with it as per law, whether you are happy or unhappy, please rest the matter there. If it's been legitimately denied using an exemption, or what you thought was not information at all, and so on. Apply your mind rationally. If you are unsatisfied with this, go to the second appellate, which is the Information Commission. For Maharashtra state bodies, the second appellate authority is the State Information Commission in Mantralaya, opposite Mantralaya, the new administrative building. And for central bodies, the Central Information Commission in Delhi, where I was a commissioner at one point in time. This is your basic structure. For that, you get 90 days time. Now, 90 days, supposing first appeal order you've got, within 90 days of that, you must file your second appeal. If you have not received anything, within 45 days is your deemed refusal. So 45 plus 90, in that period, you must file your second appeal. Now, there is a provision in the law under section 18 for what's called a complaint. When should you be filing a complaint under section 18? When RTI application not taken. Supposing you've sent it by speed post. You say, I went there and that chap didn't take, it's very difficult to prove. It's almost impossible. I would recommend not to get into that. Send it by speed post. Addressed to the public information officer. Supposing it is refused. They say, we are not taking this. Then file a complaint to the Information Commission saying, this has been refused. Please penalize the public information officer. When excessive fee is sought. Supposing there are two ways of looking at the excessive fee part. One is he says the information you have sought is of 2,500 pages, therefore please pay 2 rupees per page. That's not excessive fee. You can't say 5,000 rupees is excessive. Even 100,000 may not be excessive. On the other hand, he just says pay 10,000 rupees, giving you no explanation or calculation. Then that is excessive fee. Or he says I'll charge you 20 rupees per page. That is excessive fee. Excessive fee is not by amount directly. It is, if it is given without any calculation, just arbitrarily, that's excessive fee. If false information given. Now what is false information? It's extremely important to understand. Information, I go back, is what exists. So therefore you say there is a plot of land on which no sanction for a building has been given. A building has actually come up there. You ask under RTI and say, I want a copy of the building plans for so and so plot. The PIO says there is no building there. He is right as far as records are concerned. That's not false information. But if there is a record that information has been given, that approval has been given, then he has to provide that to you. So false information is not right or wrong in terms of physical realities. It is right or wrong or false or true depending on what the records say. The PIO's job is to give you as per the record. The PIO is not expected to go and inspect and see whether this is true or not. So please remember that. Non-compliance with section 4 can also invite, and some of us are using this, going to commission and saying that this information should be on the websites, should be disclosed suo moto, and we are getting orders and trying to pursue that. God willing, if enough of us do that, maybe over 5 years, we'll get enough information on the websites, in which case transparency leads to a curb on corruption also, or wrongdoing or arbitrariness. Because if I think what I'm going to write or what I'm going to do is going to be on the website, I have an automatic restraint. I will not do just anything arbitrarily. As per Supreme Court order, no information can be provided. I think it's a very bad order of the Supreme Court, but that's where it stands. When you go in a complaint, no commissioner can order any information to be given. It's a very silly order of the Supreme Court, but that is what it is. For threats, if you receive a threat, you can file a complaint. If somebody threatens you and says, "Tum aisa kyun karta hai?" don't file an RT. Yes, sir. Okay. Second appeal. First appeal to first appellate authority within 30 days. For getting information, incomplete information or wrong information, you go for a second appeal. The first appellate authority should decide in 30/45 days. If result of first appeal not satisfactory, the second appeal to the commission within 90 days. Section 19(5). This is important. If you go before a commissioner, onus to prove that information, denial of information was justified is on the public information officer. Really speaking, you don't need to argue by the law. But in actual practice, unfortunately, you will have to argue. Theoretically, you can take a position that it's up to the PIO to justify. You need not justify anything. Section 20, if information denied without reasonable cause, commission must penalize the PIO or deemed PIO at rupees 250 per day of delay after giving an opportunity for explaining. Maximum penalty is rupees 25,000. Commission can also recommend disciplinary action against the officer. As she rightly said, yes, it's being used very rarely by most commissioners. They are almost treating it like the death penalty, which is flawed. And because penalties are being very rarely put, the act is losing some of its sheen. Section 22 is very important. The provisions of this act shall have effect notwithstanding anything inconsistent therewith in the Official Secrets Act and any other law for the time being in force or in any instrument having effect by virtue of any law other than this act. Therefore, any prior acts, laws, cannot be taken to deny information. Somebody can say, as per my rules, I can't give you this information. As per this is confidential. In the Swarup Singh Naik case also, they quoted medical ethics and said, we can't give the information. And it was again argued that, look, this law supersedes everything earlier. This is the paramount law in terms of giving of information. It's only restricted to giving of information. It doesn't define other things, mind you. Some bottlenecks: lack of culture of transparency, lack of awareness of the law amongst citizens and PIOs, Information Commission's slow pace of disposals. This is a real threat, and unwillingness to accept mistakes. Now we'll go on to the format. On the how, we'll try and deal with a few minutes. This is a format of application for Maharashtra. Before I take up this format, I'd like to tell you one of the most powerful stories of right to information that I have heard. This happened about somewhere in 2006. There was a young boy, 21 years age, educational qualification 7th standard, from Bihar, who came to Mumbai to look for a job. Where did he stay? In a jhopparpatti with his uncle, who had been here and was doing a job. He was going around, and one day in his basti, we do RTI workshops like this in various places. So in his basti, a workshop was going on. He had nothing to do. He sat down, understood that he can take a plain piece of paper, understood that he only needs to follow the format for Maharashtra government, take a 10 rupee court fee stamp, stick it on that. Ask for what is information, not questions. Questions in the sense, not why did you do like this, because if there is a record, it has to be given, but if there is no record, nothing will be given to him. When he understood all this, he moved on. He got a job after a few days, and then he needed something that all citizens do, particularly those who are poor and are staying in slums: a ration card. Proof of identity, proof that he exists. If he doesn't have that ration card, he could be picked up by police and put inside jail and be termed as a Bangladeshi. So anyway, this boy went to apply for the ration card. He went to the rationing office, gave his application. As he was going out of the door, at the door, the peon met him and said, "Aapko ration card chahiye kya?" He said, "हाँ भाई, इसीलिए तो फॉर्म भरे." So peon said, "चाय पानी लगेगा." So this boy said, "आपको चाय पिला दूंगा." Peon said, "No, chai pani doesn't mean chai pilana." He said, "Then what do you mean?" He said, 2,000 rupees dena padega. This boy, without batting an eyelid, made a statement that always makes me feel very proud. He said, "Main ghoos nahi dunga. I shall not give a bribe." The peon shrugged and said, "Stupid chap coming from Bihar, what does he know?" He said, "Theek hai, jao." This boy went away. He continued doing his job. And he found out from others in the basti. Bastis, people from villages keep migrating at certain intervals. So people used to file for ration cards. And in about 40-45 days, everybody was getting their ration cards. He did nothing for 2.5 months. 2.5, 3 months, he waited. After that, he took a plain piece of paper, as per this format which I'll show you. Public information officer, he knew the rationing office, so he put the address and name, etc. And then what did he ask? Actually, what he wanted to know is, why have I not got my ration card? But if he asked for that, there was nothing on the records that because he is not given a bribe, he will not be given the ration card. So he asked, he said, "I filed for a ration card on such and such a day. I want information about effectively what I'm calling progress of my file." And I'll show you the format in which he asked for this. So which officer had my application on which day, and what action did he or she take on it? Question 2. I want a list of people who in the last 3 months have applied for ration cards, and dates on which they applied and dates on which the ration cards were given to them. Now if this information was given, it would obviously expose that there was no reason for this boy not to get a ration card. They had not even responded. Next day, the peon came to his house and said, "Saab ne bulaya aapko?" So he went to the office. The rationing officer said, "बैठिए बैठिए आप, अरे इनका राशन कार्ड लेके आओ, और एक कप चाय और एक गिलास पानी भी इनको दो. He did not give chai pani, he got chai pani instead. And to me, that cup of tea and glass of water represents respect to the individual sovereign citizen of India. Now, this is, I mean, I don't have his exact application, but I have framed it as if what he must have filed, perhaps. Now, application for this, I think, would be available on Moneylife website also, and probably they'll put up the presentation. Okay. So, Public Information Officer, name of the office with the address, full name of applicant, your name, your address, particulars of information required, subject matter of information, he would have put regarding my ration card application. Description of the information. I had given an application for a ration card on 5th August 2006. Copy of receipt attached. I want the following information about its progress in the following format. Date on which application received, name and designation of the officer receiving it, action taken, date on which forwarded to the next officer. There will be as many rows as the number of officers who handle the application. This is an extraordinarily useful and powerful format for applications, complaints, representations made where you've received no response. Ask for this answer. I'm not saying every time things will work out in this case. I mean, things do work out like this, but not everything works out like this. But this is a very simple way of, yes?
Including police complaints also.
Yes, certainly. Oh, including police complaints. Any complaint, representation or application for which no response is received, you can use this. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were informed. Whether information is required by post or in person, here it's written in person, but you can also say by post. Normally, I would recommend ask for it by post. It's better. Whether the applicant is below poverty line, in most of your cases, the answer will be no. This question is asked because for those below poverty line, there are no fees to be paid. Place, Mumbai, date, whichever date, enclosed a copy of the receipt of the ration card and signature of the applicant. This is the format. So for Maharashtra government, you use this format. For central government, as I said, you can use this format. Attach a 10 rupee IPO. Now I'm going to show you 1 or 2 more such cases just to, this is an actual RT application which I had filed. Now only small change I have made in this is, this was actually, see, before the National RTI Act came in October 12, 2005, we had a Maharashtra Right to Information Act for the state. So this was actually filed in the Maharashtra Right to Information Act. But this is actual case that I have filed, and I'll tell you what happened also. I've changed a few things to fit it into the current format because I don't want you confused with the old format and the new format. But otherwise, it's the same application which I'm showing you. Now, the starting point was in Times of India one morning, and this is how a lot of my RT applications start, and you can also do the same. Of the Times of India, and found there was a, on the right hand side, there's some photograph of a demonstration ladies had held at Marine Drive for a police constable, Sunil More, who had raped a minor, and understandably so. On the same day, on page 5, was a small news item which said, Police Inspector Prakash Avre of Mumbai Police, this guy was a constable, mind you, Police Inspector Prakash Avre of Bombay Police had raped a minor in September of the earlier year. He was suspended, case was filed against him, and case came up in court in December. The minor turned hostile, which happens quite often under such circumstances. And in March, Police Inspector Prakash Avre was reinstated in service. And there was anger. I said, what are we? We're there just to demonstrate and have a photo op on the newspaper? Here is a case. Now we are talking of a police constable. Here's a police inspector charged with an identical crime, and we are not bothered. After that, what happens? Parvaille. So I filed this RT application, and I'll tell you as we go along. Full name, subject matter of information, investigation and action in case of alleged rape. Period for which the information relates, last 1 year. Description of the information. According to a news report in the Times of India dated 29th April 2005, Inspector Police Prakash Avre was accused of raping a minor in September 2004. He was acquitted by the Sessions Court in February and has been reinstated in service. I want a Xerox copy of the order reinstating him along with the file notings based on which the decision was taken. That's all I asked for. I said I want a copy of the order reinstating him. It would then reveal to us the name of an officer who gave this order and the file notings. Remember, a very simple thing. Now, this was a cop, a police inspector who had been reinstated in service, and how RTI worked in this case. Okay, with the information required by post or in person by post. In case by post, I normally ask for it by speed post. Whether the applicant is below poverty line, no. 2nd May 2005, this RTI application was filed. The PIO refused to give me information, claiming that it would, what was it? It would impede investigation, I think. It would impede investigation, 81H. So I filed a first appeal, name, etc. Particulars of PIO, particulars of State Public Information Officer, PIO Bhaikala Police Station. I had filed with the Commissioner of Police, who transferred it to Bhaikala Police Station because I did not know where this matter was. Date of receipt of the order appeal, 19 June 2005. Last date for filing the appeal, 19 July it should be, July 2005. The grounds for appeal, facts of the case. I had asked for information regarding the reinstatement of Inspector Prakash Avre as per the attached application. The PIO first sent me a letter stating that the information will be provided by Bhaikala Police Station. PIO Bhaikala replied by his letter of so-and-so that the information could not be provided as it was exempt under section 81H, which exempts information which would impede the process of investigation. Grounds for appeal. This, you must apply your mind a little carefully. Okay, now what did I say here? The PI has not shown how providing information could impede any investigation. In fact, no investigation is being held since Prakash Avre has already been reinstated. The rejection is without any basis in law. And but nature and subject matter of the information required, reinstatement of Inspector Prakash Avre, name of the Office of Police Department, Bhaikala Police. Date, it was okay, 14th June 2005. I filed the first appeal. They called, usually, I mean, depends, but generally they should call you for a first appellate hearing. Though, and here I'll tell you, at times if you feel there is no point, you don't want to go for a hearing, you can write in the first appeal, I do not wish to come for a personal hearing. Please decide on the papers that I am submitting, which also I do. But in this case, I had not said anything like that. So the first appellate authority called me. I went, met the first appellate authority, and he said, Mr. Gandhi, what are you trying to do? If the court releases him, what can I do? I said, fine. But to my mind, one of the two things has happened. Either somebody framed Prakash Avre, in which case whoever framed Prakash Avre should be held responsible. And if he wasn't framed, then I think you are putting a police inspector back. That's dangerous. So I just want to know who's responsible for this. He got the point. And he was I think he was a very decent police officer. He was a senior chap. On 5th August, they sent me a letter. They did not give the information, I must concede. But in that letter, they have given it to me in writing that Police Inspector Prakash Avre had been dismissed. That is the power of right to information. Just a right to information application in one appeal. And any of you can do it. You may say, Mr. Gandhi, you were a commissioner. I was a commissioner much later than this. This happened in 2005. I'm not saying it will happen every time. But there are times when you can get phenomenal results, which the Supreme Court of India you may not get. And the critical thing is, if you see this, you can do sitting at home from your own house. Issue is yours. In a lot of things we have to get together. We say get together 500, 200, 1,000, and then when 200 of us get together, we don't know who's leading. If you are leading, I'm saying, why are you leading? And this chap says, no, it should be me, and so on, and trying to get the hierarchy moving, trying to get the politics and dynamics of all of this. This is a simple tool sitting in your own house. You think of the issue, pursue the issue. this, I must concede, is a rare case, but it has happened. And there are some, yes, miss. Okay, I didn't verify that, miss. I concede. I mean, they have given it to me in writing, but I would concede that I didn't actually. I could have tried to find out, but I didn't. I mean, Prakash Avre was not my sole objective. Okay. This is an act to provide information. Public interest is paramount. Can lead to true participatory democracy. Swaraj is my genuine belief. And this wasn't, I'm not saying this after Arvind Kejriwal started saying this. This has been my position since last 10 years. Transparency brings flaws and faults upfront and improves systems and governance. It's really about getting better governance. RTI by itself is just a tool, my friends. Truth and sunlight are healthy. This is a belief most of us have. For more on RTI, for earlier judgments by the CIC, it's the Moneylife you can go to. So for additional information on RTI, I think they'll be putting this up on the website also. So there are two resources from which you can get RTI Act, rules, etc. It's useful to do that. Okay, and now in Mumbai, for all fresh building proposals, after 15 July, they are submitted electronically and are going up on this website. So you can, for proposals that are now coming, you need not go and ask under RTI. Everything is on this website. It's supposed to be put up. It will work provided all of you put pressure. If you don't put pressure in the sense, keep looking at it for whatever you need. OD milayegi nahi, CC milayegi nahi, what is the approved plan? All this is supposed to be here. And if anything is not there, please file complaints. Because the commissioner has promised, I am heading a technical advisory committee which is trying to get most information of BMC on the website. It's a very tough battle. It's like one step forward, two steps backward. But we are trying, and I believe we will succeed at some point in time. And when we succeed, it will work only if citizens keep looking at it and complaining when something is not there. If we can make it work, we'll really have a unique thing in Mumbai. And I believe we have an opportunity of making BMC much better by making it transparent. This law has come in 2006, Maharashtra Transfers and Delays Act. It's an extremely powerful act. The first part of it says that no file should remain with any government servant for more than 7 working days. On transfers, incidentally, it also says that no officer shall be transferred who does not have his tenure of 3 years. So less than 2 years, you can certainly protest. A Khemka or a Pardeshi, people can protest and say, show us reasons why you are transferring this person. But I'm leaving that out and focusing on the delays part. It says that no file should remain with any government servant for more than 7 working days, which means about 10 calendar days. It also states that in respect to the files not required to be referred to any other department, the concerned department shall take the decision, necessary action in a matter within 45 days. And in respect of files required to be referred to any other department, decision and necessary action shall be taken within 3 months. Let's forget all the things. In 3 months, you must get a decision. It's as simple as that. If you file for a ration card, in 3 months, if you got no reply, unless, now here's the exception, unless there is something in which the period is 6 months. Barring such a thing, you say, I filed, if they want to reject, they must reject it in 3 months. If you file for a permission to repair, let's say, your house, and they're giving no response because they're waiting, jab tak paisa nahi aayega, kuch nahi karenge, don't pay money. After 3 months, file a complaint against the office to the head of the department, and disciplinary action needs to be taken against such officers. Now, the law has very strict provisions, but it's been unused. And I'll tell you one case where we've got success. This law requires disciplinary action to be taken against officers who are responsible for delays below the time specified. It's a very powerful law in Maharashtra which can empower us. If citizens use it with RTI, it can result in better governance and delivery of timely services. Its name is a mouthful: Government Servants Regulation and Transfers and Prevention on Delay in Discharge of Official Duties, Act 21 of 2006. The first part, Chapter 2, specifies that government servants must have a tenure of 3 years and it should normally be transferred only in April or May. If this is violated, reasons must be given. Citizens can use this to curb arbitrary transfers of good officers like Khemka or Pardeshi. Second part, Chapter 3, Rule 10 is most interesting. It mandates that the final decision on any file should be taken in less than 90 days. If an application, representation or complaint has been pending with the government office for over 90 days, it may be worthwhile to complain to the secretary of the department and demand that action must be taken against the officers responsible for delay as per the provisions of this act. And this is what I'm hoping enough of us, because 5, 10, 20 cases, I don't think they are going to really listen to us. But this is a law. I'm pleading with everyone and saying, if there is any work like this which is pending, for which you receive no response, please use this law, write to the secretary of the department or head of the department and say that please take action because this is violation of this rule. Please take action against the responsible officers. 90% you will get no response. If you can, please send it to me. If I can collect a few hundred of these, we will then confront the government. And in the next 2 or 3 months, if we are able to confront the government, okay, let's look at one thing. One thing is, it actually works. People start taking action, great. We have achieved our objective. I mean, nobody wants to confront. 99%, they will not, in most cases, do anything. If you let me know, give me information saying, okay, in this case I did this, I got no response, I got no response. We get a few hundred. The plan is to confront the government, and let's remember the assembly elections are just in October. So we are at a very good time. But what are we telling the government? What are we going to be telling the government? We are going to tell the government, please follow this law. The law was not, we didn't even ask for this law, but the law has been framed. There is a historical reason, I'm not going into that. But if we make an effort, RTI only gets you information, this can actually get you results. Because when they do not decide, we have a legitimate application for something and they don't do anything, you can hold them accountable like this. And if hundreds of us start doing it, there is no reason why we can't make this act work. The government will not be able to withdraw this act. At this stage, as I said, before the next assembly elections, there is no way anybody can withdraw this law. And therefore, if we use this opportunity, we may actually set a huge trend for the whole nation. Now, step 1, if anyone has sent an application, complaint or representation to any government department which has not given any response for 45 days, it would be useful to ask in RTI the same format that we talked of. Step 2, when the reply shows certain officers have been held on to the application, complaint, representation for more than 7 working days, file a complaint to the head of the department asking for disciplinary action against such officer for violation of Act 21 of 2006. Now, this is what I asked a friend to do 2 days back. He had filed an RTI application some months back, and he then asked me, he said, Shailesh, what do I do? I said, you finished your first appeal period, so you can't do anything. I started thinking about this act. I said, even an RTI act not replied to, let's use this law. So this is a letter I suggested he write. I had filed the RTI application 20 June 2013 in the building department. I have not received any communication from them. I would like to bring to your notice that as per Rule 10 of the government, etc., if a file remains without a final disposal in a department for more than 3 months, disciplinary action is required to be taken. Request that you conduct a preliminary inquiry in this matter within 15 days as per rules and send me the inquiry report. I request you to conduct a preliminary inquiry in this matter within 15 working days and request that the inquiry report be sent to me. Now, inquiry report, I am adding my own touch. If they don't send you, file an RTI application saying what happened with this inquiry. If they have done nothing, that's the stage then we'll confront the government with. And well, there's one success. It's like the Prakash Avare success. Let me concede it very honestly. I think it's sometimes when you keep trying a lot of things, some things work out way beyond expectations. I think 4th or 5th April or 6th April, I read in the Hindustan Times that CBI had been asking for sanction of prosecution against Jairaj Phatak and Pradeep Vyas. And for whatever 15-20 months, this was not being done. CBI was sending them reminders like beggar again, you know, saying, humko de do. So I sent this email on 7th April in the first half of the day, which said, It has been reported, I sent it to the Chief Secretary, Sri Saharia. It has been reported that CBI has requested sanction to prosecute so-and-so and so-and-so, and no sanction or rejection has been communicated so far. I would like to bring to your notice that as per rule so-and-so, your file remains with the decision. Disciplinary action is required to be taken. I request you to conduct a preliminary inquiry and let me know. 10th April, there's a report in the Hindustan Times which says sanction for prosecution has been given. And the reporter claims that his source has told him that this email shook them up. Now again, I'm not saying every email and every letter we say will shake them up. I concede this is like the Prakash Avre case. I have sent other letters, they will not work. But even if they don't work, let's collect data together, and I'm sure we can make it work. This law can do a phenomenal change for the whole administration in Maharashtra, provided there's only one condition, friends: enough of us try. We have for too long been lazy citizens. If we say we are Shahenshahs and Begums, then we also have responsibilities of Shahenshahs and Begums. Most of us are very happy to say the politician is responsible, the bureaucrat is responsible.
Most of us wait for a Birbal like you.
I am not yet a Birbal, sir. My point is, if you take it up, there is nothing that can stop us. And today, I would also concede, I think last few years there is something in the air. If we take advantage of this, we can actually make this democracy far more meaningful. Responsibility, my friends, is with you. Okay. This is a slogan I'd like to share with you, my friends. Mera Bharat Mahan. We say this in a lot of places. We write also. We don't really believe it, do we? So I say, Mera Bharat Mahan nahi hai. मेरा भारत महान नहीं है, पर यह दोष मेरा है. I, the individual sovereign citizen of nation, have to make it right. It's my responsibility. Thank you, friends.